I am Sean Seymour. I'm a professor of law, professor of chemistry, and enterprise scholar at Vanderbilt University, and also a double alumnus of the University of Notre Dame. So here is the structure for the session. So I'm going to say a few words about each of our invited speakers, allow them to give their talks, which will last for about 20 minutes each, and then I'll open the floor for discussion. So I'll start with Professor Brinig, who's to my immediate left here. Professor Brinig holds the Fritz Duda Chair in Law at Notre Dame Law School. She joined the faculty in 2007 after having taught at the University of Iowa and George Mason University. Professor Brinig is best known for her expertise in family law. She sits on the Executive Council of the International Society of Family Law and recently published through the University of Chicago Press, Family, Law, and Community Supporting the Covenant. This book offers a distinctive study of legal reform from the perspective of family dynamics and social policy. Professor Brinig has also written books and articles on domestic violence, child support, Catholic schools, charter schools, divorce, elder abuse, and cohabitation. At Notre Dame, Professor Brinig is a fellow of the Institute for Educational Initiatives and works closely with the Institute's Alliance for Catholic Education, also known as the ACE program. She continues to conduct groundbreaking research with her colleague and my former mentor, Nicole Garnett, on the negative impact of Catholic K-12 school closures on poor neighborhoods. Professor Brinig has been honored for her work at Notre Dame, at a Notre Dame football game, and has won the Distinguished Professor Award at George Mason University, and she's also a member of the American Law Institute. Next, I'll introduce to you Professor Lorenza Violini, who's to my far left. She's a professor of constitutional law at the University of Milan. She completed her studies and research in the U.S. and Germany, studying in numerous issues related to relationships between different levels of government, federalism, and regionalism, and fundamental rights. Professor Violini also taught public law and European constitutional law at the University of Pavia and European integration at the University of Budapest. Professor Violini writes on a broad range of topics, which include the constitutional right to health care, equity, equality, marriage and family, freedom of choice in the Italian educational system, adoption, non-discrimination, and social rights. Professor Violini is a member of the editorial board of some leading Italian legal journals, and she is also a member of Italian and foreign academic law associations. And finally, Professor Melissa Moschella, who's in the middle here. She is an assistant professor in the School of Philosophy at the Catholic University of America. She previously was the Thomas W. Smith Postdoctoral Research Associate in the James Madison Program for American Ideals at Princeton. Professor Moschella's areas of interest are political philosophy and ethics. Her recent academic publications include Social Contract Theory and Moral Agency, Undertaking the Roots of an Uncaring Society, and Personal Identity and Gender, a Revised Aristotelian Approach. Professor Moschella has also published a number of articles on parental rights and conscious rights more generally in the New York Times, the New York Daily News, the Public Discourse, and National Affairs. I should also mention that Professor Moschella has prepared a book manuscript, The Fundamental Case for Parental Rights in Education, which is currently under review with Oxford University Press. At Catholic University, Professor Moschella teaches biomedical ethics, a course called The Classical Mind, and a course called The Modern Mind. So I will now turn the floor over to Professor Brinig.
Thank you very much, Sean. That was very generous. I want to begin this talk by saying that in some ways I'm an outsider, commenting on something that where I haven't directly experienced what's what's going on. I've never had fertility issues, au contraire. I have never been a surrogate. I have watched other people in my family and close friends struggle with infertility and with birth parents who change their minds. I have known same-sex couples trying to figure out how to become both legal and biological parents. This is my third talk on surrogacy in the year since 1976 when I started teaching about family law. The first one was in 1987, while the Baby M case, the first famous American surrogacy case, was making its way through the New Jersey courts. I was on a panel with my colleague and co-author, June Carbone, and she said as part of this panel that if somebody paid her or offered to pay her $2 million, that she would be a surrogate. And I thought about it, and I thought there was no amount of money that could convince me to be a surrogate mom. The take that I gave that day was sort of a family law take, that surrogacy was problematic because it allowed people to commodify both the children involved and the pregnancy or childbirth experience. That in many cases it involved payment for babies, which is illegal everywhere in the US, that it had the tendency to be involved with exploitation of poor women, especially those of color, and that it involved issues of pre-birth consent, which also is illegal in most places in the United States and around the world. Pre-birth consent to placement outside the biological family. In some ways, when I gave that particular talk, I was motivated by the fact that I had been through pregnancy and childbirth. I was a mom 4 times over, and that I couldn't see giving up any of my daughters for any amount of money. The second time that I talked about surrogacy was at a panel at the University of Virginia. It was in March of 1995, and it was called New Directions in Family Law, and my job was to give some comments and write a paper about critiquing Professor Richard Epstein's, who is a law and economics professor at the University of Chicago, who writes about everything, but he had a paper talking about specific enforcement of surrogacy contracts and advocating them. I did this because he was a law and econ professor, and this was sort of my job. The take that I had on Professor Epstein was a law and economics reason why I felt that these contracts shouldn't be specifically enforced. And what I said then was that there were some information problems that were involved in sort of asymmetric information issues. That is primarily that the woman who was pregnant couldn't know how much attachment she'd feel to the particular child with whom she was pregnant until after the child was born. She couldn't know, unless she'd had children, even what the childbirth experience was going to be like. And based on my own very small sample of 5, I can tell you that it varies from one child to the next. Secondly, there were external effects, and they might be negative external effects, not only on sort of the general public and our feelings that this isn't quite a good thing, but also that there usually in surrogacy contracts, in the ones that are sort of standard, the woman who is to act as surrogate already has children. She's already been through pregnancy and childbirth at least once. So there are children that she has that are going to know that their mom is pregnant at some point, and that are going to see their sibling being, or what looks like their sibling, being given to somebody else. And I was concerned about the psychological toll on them of feeling that they might be given away should their family get into economically tough times. And third, I was concerned about the middle people in this particular market, that there was a potential for the lawyers and doctors and matchers involved to be extracting a lot of the money that could go either to the surrogate or that just belonged to the birth parents, and that they were profiting by the need on the part of the family of the surrogate, because usually these are financially needy people, and also the incredible desire to have a child, and particularly to have a genetic child, on the part of the so-called intended family, the couple that wants to end up with a baby at the end. So my interior feeling was pretty much the same, but the words that I gave were different. And today I'm going to give you my third take. And this is now 25 years since the first time. And I want to put surrogacy a little bit in the context of what the church has to say about it, and both about surrogacy and about being a mom, being a mother. Meanwhile, not only have I spoken about this before, but the law has changed a lot and the technology has changed a lot in the last 25 years. In California, parenthood is, in cases of artificial reproductive or assisted reproductive technology, as our later commentators are going to talk, basically determined on intent, who intends to become a parent. A number of states have acted since the Baby M case to regulate or to ban or to promote surrogacy in some way, and they vary. They're all over the map. Where we're sitting, Indiana bans surrogacy. Those contracts are void. Our neighbor to the west, Illinois, permits it and permits compensation to the surrogate mother for all of her expenses, which can be, modified to include basically anything. And in other states, and California is one of them, surrogacy is fine. This kind of trend and all over the map kind of feeling is also true in Western Europe and on the Australian continent, where there are a whole lot of different kinds of approaches to it. In a lot of continental Europe, surrogacy is illegal. It is legal in India, and so there is a thriving international medical tourism market in India for surrogates, and with a whole host of legal issues about what happens when these children who are being born by Indian women but are genetically, Italian or German or something like that, attempt to leave the country or to go back to their country of origin. From a technological point of view, in vitro fertilization has become a lot more routine and more successful. And most of the cases that arise today are cases that involve so-called gestational surrogacy, where the surrogate mother is no longer the genetic mother of the child. The ovum comes from either the intended mother or a third party. And a bill that went through the California legislature within the last year or so, but was ultimately vetoed, would have allowed a child to have more than two parents, more than two legal parents, to allow for accommodation of various donors as well as possibly surrogates or intended parents. Surrogacy also frequently is used by same-sex couples who biologically cannot otherwise have a child of their own, and sometimes in a lesbian couple, one woman will be the surrogate and the other one will be the genetic parent, so that both of them can be legal parents from the get-go, and surrogates are used by gay couples as well. There's also been some research done on the kids of surrogates, and the answers are complex, and I'm not sure that any of these studies is I'm sure that they're not bulletproof, so to speak, but the evidence that's out there seems to be that while the children of surrogates are basically psychologically whole, they're not, incredibly disturbed, there is some evidence that they don't have the same kind of sharing relationships that most kids have with their mothers. They don't have the same kind of mutuality with their mothers that most children have. And that as adults, they're somewhat disturbed about the choices that their parents made. The church's position, of course, is that life begins at conception and lasts until natural death, and that all of us are imbued with dignity from the moment of conception until the moment that we die, and need to be treated as human persons with that kind of dignity. Marriage, and therefore parenthood, are to reflect the church and the Trinity. It's the communication between spouses that creates life, much as the Holy Spirit is the love passing between the Father and the Son. The U.S. Council of Catholic Bishops say that parents should regard as their proper mission the task of transmitting human life and educating those to whom it has been transmitted. They are thereby cooperators with the love of God the Creator and are, so to speak, the interpreters of that love. The Second Vatican Council says, because of the dignity of the child and of marriage, and because of the uniqueness of the mother-child relationship, participation in contracts or arrangements for surrogate motherhood is not permitted. Moreover, the commercialization of such surrogacy denigrates the dignity of women, especially the poor. And I will note that I had no idea that the church had said that when I made those arguments back in 1987. Pope John XXIII wrote, "The transmission of human life is entrusted by nature to a personal and conscious act, and as such is subject to all the holy laws of God, the immutable and inviolable laws which must be recognized and observed. For this reason, one cannot use means and follow methods which could be licit in the transmission of the life of plants or of animals." The way that the law thinks about surrogacy and the way that we've conceptualized a lot of this thing is in terms of rights, of the rights of the mom to be able to decide whether or not to carry a child for someone else, the rights of the infertile couple to have a child who's biologically there, and tends to miss frequently the fact that we're dealing with relationships, not really rights, and that there's a child involved, at least one child, and maybe more. French writer and philosopher Fabrice Hadjadj, who converted to Catholicism in 1988, wrote, "Life is no longer accepted as it is given. People try to transform it, starting from an idea. Then, instead of welcoming a child, we make a product. Starting from a design of perfection, we reduce the being to its functions. Instead of perfection, we get a degradation of being to a utility. On the contrary, if I welcome the other who is given to me, I truly welcome the mystery of life. Life lies not in its practical performance, but in its enjoyment. In this way, I enter into the poet's way of looking at things." And I want to add, at the risk of being really blasphemous here, that we might want to think about Mary, the mother of Jesus. Was it convenient for her to say yes to God, to be for a time an unwed pregnant woman, later an inconvenient guest choosing a most unpropitious time and place to give birth? To be a refugee in Egypt? Did she suffer the guilt from knowing that on her son's behalf dozens of other people's babies had been slain? From the very first, she, more than most of us as parents, had to give her son away, to be available to the magi and the shepherds, to let him be about his father's business in the temple, to be so available to his flock that the Son of Man has no place to rest his head. She had to see her son unjustly accused, ridiculed, tortured, and finally put to a conspicuous, demeaning, and horrible death. In her love for Christ and for all of us, made her children by Jesus' words to John on the cross, is our fully human model for unconditional love, or caritas, which so characterizes being a parent. Was she just like a surrogate? Wouldn't it have been in Jesus' best interest for God to have just swept up the infant Jesus after Epiphany and had angels care for him as they did after his 40 days in the desert until he was ready to be baptized by John at the beginning of Mark's gospel? During Christ's infancy and youth, she and Joseph needed to nurture and protect him, to teach him about what living in a family was like, since he did know already about relationships in the Trinity, but they are at least pure and in some ways less complicated by uncertainty and death than are our human ones. She and Joseph taught him to speak and to pray in a human voice. And with that, I'll let other people talk. Thank you.
No, just want to know how I can go ahead. Here. This one. This one. Thank you. And this one will take you back. Okay. Okay, great. There you go. Okay. So good morning, ladies and gentlemen. I was very generously presented by our president of the session, but I would like to add something. I'm really very happy to be here with my friend and to be invited by the Center of Notre Dame Center for Ethics and Culture, and I thank very much Carter Sneed, a good friend for a long time. And I should say, as a promise to Carter, that I would like to work on the subject, because we would really very strongly work on the subject comparing Europe and the United States. So the title of my paper is Human Dignity and Human Rights in the Era of Genetic Research, and I would like to start with some basic assumption, saying that human genetic research touches upon many facets of the human right discourse that involves privacy, human dignity, right to health care, freedom of research, access to knowledge, equality, and non-discrimination. Despite these broad implications, though, recent case law does not deal directly with human rights. Both in Europe and in the United States, disputes are mainly decided on the legal basis offered by patent law. As lawyers know, patent law aims at granting property rights to the inventor, who becomes the only subject legally entitled to draw economic benefits from what he invented. In recent years, biotechnology has called into question the possibility of granting property rights relates to life, the bios of the biotechnology, and later also to human life. As seen in the title of a recent book, the question in simple terms is, who owns you? Where you means your body, your genes, your cells, and so on. Go ahead. Who owns you? Okay. My presentation will focus on cases decided by American and European courts in the two fields related to human genetic research, and in particular to who owns the property of human genes and human cells. And here are the two set of cases. And my analysis concludes that since patenting items related to the human being involved not only technical requirements of receiving the patent, but also the moral issues implied in granting property rights to the human body, there will always be the need to clarify and assess in judicial terms the compatibility of scientific progress with the basic values enshrined in constitutional law, the most important of which is human dignity. So, first, I'd like to start with US and patenting of genes. Let's go together through this sentence. From the late 80s, a storm surrounding the wisdom, ethics, and economics of human gene patents have been brewing. The various winds of concern in this storm touched on the impact of gene patents on basic and clinical research, on healthcare delivery, on the ability of public healthcare system to provide equal access when faced with costly patented genetic diagnostic tests. Myriad Genetics found itself in the eye of the storm since it commercialized a hereditary breast cancer diagnostic test. So you might know what is Myriad Genetics. It's a private company that obtained several patents after discovering the precise location and sequence of BRCA1 and BRCA2 genes, mutations of which can dramatically increase the risk of breast cancer. Having identified the gene's typical nucleotide sequence, Myriad was able to develop medical tests for detecting mutations in these genes and for assessing the patient's cancer risk. Myriad is a very powerful company, has a relationship all over the world. And you might know the story. Angelina Jolie had this test done and took consequences from this test. But these tests are very expensive because Myriad not only dominates the market, but set also injunctions to competitors who also tried to make the use of the genes because it owned the genes. In order to oppose to Myriad policy, patients, advocacy groups, and other doctors filed a lawsuit seeking a declaration that Myriad's patents were invalid under US law, which states, this is the relevant provision. There was strong opposition, of course, to the Myriad policy in patent law. The very powerful American Civil Liberty Union was one of the petitioners against Myriad. And they had two ideas, that patent was unconstitutional and invalid. So, invalid under this provision, whoever invents or discovers any new and useful process, machine, manufacture, this is important for the following decision, or composition of matter, or any new and useful improvement thereof may obtain a patent, and so on. And under the Constitution, the petitioners claimed the violation of several constitutional principles, like Article 1, First Amendment, and 14th Amendment. So what happens after this challenge? The U.S. District Court for the Southern District of New York ruled that Myriad patents were invalid because they cover no products of manufacturer, but products of nature. And later on appeal, the court ruled that the contrary, the patent was legal since the act of isolating DNA is an inventive act that entitles the individual who first isolates it to a patent. So we had two different decisions, and this is the reason why the Supreme Court was called to make a decision, an ultimate decision. And according to the court, which is a very recent decision, though, June 13, 2013, according to the court, Myriad did not create anything. To be sure, it found an important and useful gene, but separating that gene from its surrounding genetic material is not an act of invention, and therefore the patent was held invalid. A brief note on that case, no constitutional argument was considered by the court. There are technical cause for that, but I would like you to focus on that idea, with only a decision made on the basis of patent law, and patent law means property. So, second set of my analysis, patenting genes in Europe. The legal framework on the issue is very different from the United States. There is a technical part in the European Patent Convention, Article 53, which is more or less similar to the previous rule that I put on the slide. But the difference is that under European law, which is international law indeed, because it's a convention, European patents shall not be granted in respect to inventions that the commercial exploitation would be contrary to ordre public or morality. And the same ethical imprinting is present in the directive, European Directive 98/44. You can go through, but the relevant proposition is inventions shall be considered unpatentable where their commercial exploitation would be contrary to ordre public or morality. And moreover, there is a prohibition to use human embryos for industrial or commercial purposes. The Myriad is present in Europe and applied for a patent which was granted, in fact, in 2001. But then the opposition from the medical class was very strong, and especially the very powerful Institut Curie opposed to the patent. And there was a lot of protest, and the patent was revoked in 2004, but was finally upheld with a lot of restrictions in 2008. And the struggle is still ongoing. The most recent actions dates from September 2010, with a decision from the European Patent Office on BRCA2 patent that is now under appeal. So it is interesting to note that comparing US and the European legal framework, in Europe, the grounds for opposition are different. In Europe, the law, though there is this strong ethical imprinting in the framework, did not discuss the nature of the gene, but only challenged the not compliance of Myriad's patent with the criteria listed in the European Patent Convention. So lack of novelty, lack of inventive step, lack of industrial applicability, and incomplete disclosure. As it was said in commenting this situation, the pendulum has swung farther in the US than in Europe. What does it mean? Means again that the judges, the European judges, did not consider the nature of the object for who was in discussion in the patent, so gene. They just look at consequences. So no real attention was given to the fact that patent law gives property rights to somebody. And this might be there might be a procedural problem, because most cases in Europe as to genes were decided by the agency, by the patent agency, and not by court. Comunque, as a result of this war, up to now, myriad patents in Europe still exist, but in a restricted form that does not impair the possibility of other bodies to develop the test, the diagnostic cancer test. And in fact, in Europe, those tests where they are offered are much less costly than in the United States. Okay, let's go to the second set of cases, US and human stem cells. The myriad decision made by the Supreme Court had an immediate consequence on the regulation of human stem cell in the US, because very soon after the decision, in July 2013, some petitioners have challenged in court, not anymore in the patent office, but in court, one of the patents owned by the Wisconsin Alumni Research Foundation that was related to the in vitro culture of human embryonic stem cells. It was a patent called a bottleneck patent. So once you have this patent, all what follow, all the subsequent research that you can make is blocked. WRF is a non-profit corporation, but has a very powerful profit part that commercializes the license. And therefore, patenting embryonic stem cell in US is a general common practice. No moral issues are considered when you grant the patent. You remember the law, no? It's the same. The patent law is very simple, has those requirements for granting the patent, but no moral consideration as a difference in contrast with European legislation. But we can ask ourselves, are really moral considerations excluded by patent law in the United States? We have done a lot of research in the patent office cases, and we found out that in fact, in US, the US Patent and Trademark Office has rejected applications to patent non-human chimeras. There was no explicit provision for that, but nonetheless, the Patent Office said on moral grounds, we can say, that such a patent is not legal. And I quote the part of the case. The Patent Office said, inventions directed to human and non-human chimera could, under certain circumstances, not be patentable because they would fail to meet the public policy and morality aspect of the utility requirement. You might recall that must be useful. Something can be patented only if it is useful. And so the Patent Office said, well, but if it is immoral, cannot be useful. And there is another case decided by the Patent and Trademark Office that said that the Congress, I quote, could not have intended humans to be included as a subject matter under the provision, under the law, because this interpretation would have been against the 13th Amendment, which abolished slavery. let's come to the other side of the pond, Europe and the embryonic stem cells. As we have seen before, the European directive has a strong moral imprinting and moreover prohibits uses of human embryos for industrial or commercial purposes. Now the issue becomes the definition of human embryos, because it's not yet human embryonic stem cells. The directive prohibits only the use of human embryos. And so in front of several European court, they have to decide if the patent was possible. We had the first decision of the European Board of Appeal of the European Patent Office that rejected, it was a Wharf case, the Wisconsin foundation that claimed to have the patent. The European Board of Appeal rejected the patent on embryonic stem cells because their production involved the use of a blastocyst, which is in fact an embryo. And we had a very important case back 2 years ago, the Brustle case. He filed a German patent in 1997, so very early in the field of this research, to process the isolation and purification of neural precursor cells processed from embryonic stem cells and removed at the blastocyst stage. The case was, the patent was challenged in a German court by Greenpeace, and the court, the national court, decided to refer to the ECJ, to the European Court of Justice, in order to determine whether the human embryonic stem cells, which served as base material for the patented process, constitute embryos within the meaning of Article 6.2. And the response was very clear. The court, wait a moment. The court gave a very broad interpretation of what should be considered a human embryo. And the court ruled that, I quote, any human ovum after fertilization, any non-fertilized human ovum into which the cell nucleus from a mature human cell has been transplanted, and any non-fertilized ovum whose division and further development have been stimulated by parthenogenesis constitute a human embryo. So they gave a very broad interpretation of the term, very respective for human dignity. And in deciding the case, the European Court of Justice was very clear in saying that patenting human embryonic stem cells is against human dignity. But the struggle, the war, the legal war is not ended. Coming back to the German court in order to decide on the patent, on the merit of the patent, the court annulled the patent only in part because in abstract, they say, if you are able to extract a human stem cell from the blastocyst without destroying the blastocyst, you are allowed to have a patent, which is, very problematic because the court did not consider damages that can be done to the blastocyst in extracting the stems, the cell. Theoretically, it is possible, but in fact, a lot of damages can occur and the blastocyst can be destroyed. So, and another risk for the Bristol decision, which was very important for protecting human dignity, is the fact that another court, very, very recently, April 2013, has asked the European judges to clarify again the definition of human embryo. Here the issue is pretty subtle. They asked to redefine the idea of human embryo in a sense that they were not sure to if the I read the easier. This is whether or not a human embryo means capable of commencing the process of development of a human being, or simply capable of commencing the process, even if that process is not capable of leading to a human being. And the issue here is the parthenogenesis, and which we know is a process of stimulating ova to develop, but of course it is not possible for that to get to the human being. So as you can see, in Europe, the situation is pretty problematic. We had a very strong opposition to patent for human embryos, but now things are changing. And things are also changing on another level, as we all probably know. Science has done a lot of progresses in the research, and now it is possible to have stem cells not taken from the embryo but induced. So this will change probably the legal framework and the legal discussion on the issue. So let's go briefly to a conclusion. We had the issue, who owns you? And so if the human body cannot be the object of a patent, so a property right, does this principle extend to human embryo stem cells and to genes? So we have seen that in US, the answer is, of course, no in relation to genes, myriad case, and so here Europe should learn something from the United States, even though in fact in Europe the results are more or less the same, because in fact the patent is possible, but it is not possible to have monopoly over the test. So the human the human health is protected as well. But in the field of embryonic stem cells, we could say ad interim that Europe can have something to say to the US case law, because in principle stem cells, because of the risk for the embryo, are not patentable. So thank you for your attention.
So I'll just start as the handout's going around with some introductory remarks. So I'm talking about body-soul unity and the ethics of artificial reproductive technologies. And the basic point will be that children have a right to be loved by their biological, by which I mean genetic in this paper, parents. And now that many children conceived with the help of donor sperm or eggs have reached adulthood, we find that many of these donor-conceived adults have claimed a right to seek to know, or at least to know about their biological parents, leading to an outlawing of anonymous gamete donation in a number of European countries and some Australian states, and a general trend toward the use of non-anonymous donors, even in places like the US, where anonymous donation remains legal. Now, this shift away from the use of anonymous sperm and egg donors parallels the shift toward greater openness in adoption and marks an increasing recognition that knowledge of one's biological origins and contact with one's biological parents, when possible, are important for human well-being. This recognition and the resulting move away from anonymous gamete donation points to a more fundamental critique of donor conception. Indeed, the basic premise of arguments against anonymous gamete donation, the recognition that children have an interest in knowing their biological parents, implies that conceiving children with donor gametes is always morally problematic, even when the donor is not anonymous, because it always involves conceiving children with the intention of depriving them of a parental relationship with one of their progenitors. Thus, it is different from the case of adoption, in which a child already exists, and putting that child up for adoption is judged as the way to give the child the best possible care in admittedly non-ideal circumstances. Yet, while it seems hard to deny that children can benefit from access to information about their biological parents, many remain skeptical that being raised by biological parents is important for the well-being of children. After all, many adopted and donor-conceived persons flourish in life, and many children raised by their biological parents fare poorly. Statistically, we know that children tend to fare best overall when raised by their married biological parents, but some argue that this is simply due to cultural attitudes that place so much emphasis on the importance of biological ties. So, an ethical evaluation of donor conception requires a deeper philosophical investigation of the common view that parent-child biological ties really matter in themselves. What we need to ask, in other words, is the following question: are there unique benefits to children in being raised by their biological parents? Or is a biological parent, in principle, fully interchangeable with any other equally competent and loving parental figure? In this paper, I argue that the parent-child biological bond really does matter in itself, because there is at least one unique and important benefit that biological parents, and only biological parents, can provide for their children. That benefit is the benefit of their parental love. My claim, in other words, is that children have a fundamental interest in being loved by their biological parents, and that, strictly speaking, no one else can replace biological parents in this regard. Moreover, except in cases of genuine incompetence, biological parents cannot love their children as they ought to, as their children need them to, without raising those children themselves. Certainly, when biological parents cannot or will not raise their own children, others can generously take on the task and do an excellent job. And in doing so, of course, they show great love for those children. But their love cannot replace the absent love of the child's biological parents, any more than the love of another man or woman can replace the love of an absent or deceased spouse. The reason why biological parents' love is irreplaceable to their children is that simply by virtue of their biological connection to their children, biological parents have an intimate and personal relationship to those children. The absence of their love is not like the absence of a stranger's love, because even if they've never actually met, biological parents are not strangers to their children. Or are they? For those who view the person as essentially a bundle of interconnected psychological states, a merely genetic parent, of which a gamete donor is a paradigm example, actually is a stranger to his biological child, because donor and child have had no conscious interaction with each other. If, on the other hand, human beings are essentially animal organisms, rational animal organisms, but animal organisms nonetheless, then gamete donors are not strangers to their children, because donor and child have an intimate and enduring connection to each other at the organic or bodily level. Thus, one's understanding of the ethics of donor conception ultimately turns on one's view of the human person. Only if one holds that the human person is a psychophysical unity, a unity of body and soul in the Aristotelian Thomistic sense, can one make sense of the claim that biological ties matter, and that children have an interest in being raised by their biological parents that is not simply the result of prevailing customs or social conventions. In what follows, therefore, I provide a brief defense of the claim that human beings are a unity of body and soul, and then provide further explanation of the connection between that metaphysical claim and the moral claim that children have a fundamental interest in being raised by their biological parents. In the final section, I will conclude that donor conception is always an injustice because it intentionally deprives a child of the important right to be loved by his or her biological parents. So the first section on the human person as a psychophysical unity, a unity of body and soul. Now, the dominant view of identity among moral philosophers and philosophers more generally, and the one that underlies skepticism about the moral relevance of biological ties, is what's usually referred to as the psychological view. On this view, the identity of a person, or at least what matters about identity, is determined exclusively by psychological features: consciousness, memory, desires, choices, thoughts, and so on. Another view, which holds that human beings are essentially living animals, is called animalism. The most prominent version of this is defended by Erik Olson, and it completely reduces human identity to animal identity. The account I defend differs from both. Unlike the psychological view, on my account we are essentially bodily persons, not some form of non-bodily conscious self that merely inhabits and uses a non-personal body as an extrinsic instrument. And while, like Olson, I consider biological identity as essential and intrinsic to personal identity, and I consider continued existence of the human organism as a necessary and sufficient condition for continuity of personal identity, my view differs importantly from Olson's version of animalism because I deny that personal identity can be reduced to biological identity. The account that I defend is based on Aristotelian Thomistic hylomorphism, according to which human beings, like all material substances, are metaphysically composed of matter and form. Aristotle uses the term psyche, or soul, to refer specifically to the form of living things. The soul is the unifying and vivifying principle that makes the material elements of an organism into one organic substance rather than a mere aggregation of separate substances. Crucial to my account of personal identity, and for the understanding of the moral relevance of genetic parenthood, is that the human soul is the formal principle of all of a human being's operations, everything from homeostasis and digestion to deliberation and conceptual thought. The soul that is the form of the human body, making the body be a human body, as the formal principle of biological identity and integrated organic functioning, is the same soul that is the principle of the human person's rational capacities. It is the soul that makes the body be and be what it is. There's no living body without a soul, no human body without a human soul. And the human soul is the formal principle of all of the acts and operations of the unified psychophysical substance that is the human person. Thus, continuity of biological identity, that is, continued existence of the same human organism, is a necessary and sufficient condition for continuity of personal identity, and our identity as human organisms is essential and intrinsic aspect of our overall personal identity. This is not because biological identity exhausts personal identity, but because a human organism's existence and continued existence over time shows the corresponding presence of the human soul as the organism's formal principle of integrated functioning, and this, in turn, shows the presence of the entire soul as the formal principle of all a human being's acts and operations, including conceptual thought. Now, in the interest of brevity, I will skip over my defense of this account of identity, except for one brief dialectical point, which is, if, like most people, you think that a human organism, only if you think that a human organism is a human person, can you have grounds for thinking, as most people do, that rape is a genuinely personal violation, not just a violation of property, even if the victim is unconscious, never finds out, and suffers no physical harm? Okay, so let me skip then to the next section, in which I now explain how this metaphysical view implies that the biological parent-child relationship is itself a personal relationship that makes the child uniquely dependent on each of his or her biological parents for the ideal fulfillment of developmental needs, particularly the basic need to be loved by one's biological parents. I will argue further that the existence of this personal relationship is what grounds the special and non-transferable obligations that biological parents have to their children obligations that are the correlates of children's right to be loved by their biological parents. Now, in claiming that the biological relationship, parent-child relationship, is a personal relationship, I assume that a relationship is a union or interconnection of persons with respect to one or more dimensions of their being, intellectual, volitional, affective, or bodily, and that a specifically personal relationship, in the strict sense, is one in which this connection is based at least in part on unique identifying characteristics of each person. Because in personal relationships, the parties are connected based on unique personal characteristics, those in the relationship are irreplaceable to one another. If one's husband dies, for instance, one might choose to remarry, but no one can actually replace the husband that died. Those in a personal relationship are irreplaceable to one another because being in a personal relationship with someone implies that there are things that person, and only that person, can do for you in the broadest sense of the word. In other words, being in a personal relationship with someone means there are some benefits that you, and only you, can give to the other person in the relationship, and vice versa. I will call such benefits personal benefits. A paradigm example of a personal benefit is the specific love of the person with whom one has a personal relationship. To avoid confusion, I should note here that while I recognize that love in its fullest sense involves an affective component, here I'm speaking of love primarily as a commitment of the will to the good of another person, the strength of which will depend, rightfully varying, on the nature and closeness of the relationship in question. So this understanding of relationships is important for recognizing the nature, scope, and weightiness of our obligations to others, because aside from, and perhaps even more importantly than voluntary commitments, it is the nature and closeness of our relationships to others that determine the relative weight and priority of our obligations. As Alistair McIntyre has pointed out, human beings are not only rational animals, but dependent rational animals, whose bodiliness and whose particular mode of exercising rationality as bodily beings implies vulnerability and dependency at all levels. Based on this understanding of human dependence, he argues that human beings naturally form part of a network of givers and receivers, in which what we receive and what we were called upon to give depends not on strict reciprocity or consent, but largely on need and capacity, respectively. We can achieve our fulfillment as human beings, claims McIntyre, only by finding our place within such a network of givers and receivers, a place which is determined by the nature of the relationships, chosen and non-chosen, that we have with others. Translated into the language of obligation, this means that the needs of others and our specific capacity to meet those needs are what fundamentally determine our obligations, and that the order of priority among our competing obligations to others is determined by the closeness of our relationship to the person in question and the importance of that person's need for his or her overall well-being. Further, when what the person needs is a personal benefit, a benefit that only a specific person can provide, then the obligation to provide that benefit is a non-transferable one. That is, it must be carried out personally. In a weak sense, everyone has a relationship with every other human being, at least at the bodily level, insofar as we all share a common genetic origin and inheritance. Further, the love of any particular person is always irreplaceable in the strict sense to every other person. Does this imply, then, that every person has a non-transferable obligation to love every other person? Well, yes, it does. And this simply means that every person has a general obligation to promote the overall well-being of every other person, at least by not being a hindrance. The well-being of some, however, will rightfully take priority over that of others in accordance with the closeness of one's relationships and the importance of the benefit that one can provide. Now, the biological parent-child relationship is a relationship based on a connection at the biological level, a connection of biological causality and strong genetic similarity, and this relationship is personal because it is indeed based on unique person-identifying characteristics. In fact, a child's relationship to his biological parents is identity determining. To be born of different parents is simply not to exist, it's to be a different person. The child's relationship to his biological parents is, at least initially, the closest of that child's human relationships. This, combined with the observation that receiving proper care is crucial for the child's current and future well-being, this implies that biological parents, at least initially, have the strongest obligation to ensure that their child is well cared for. Translated into the language of love, this means that the love parents owe to their children is special and prioritary, meaning that it takes precedence over most other loves. Further, because love is a personal benefit, the obligation to love one's biological children is a strictly non-transferable one, meaning that biological parents must love their children themselves. It is literally impossible for anybody else to do it for them. Yet why can't biological parents fulfill their obligations to their children simply by ensuring that competent others will raise the child? The reason is that the special and prioritary love that biological parents owe to their children is almost always incompatible with failing to raise those children. The exception, of course, is where there are extremely serious countervailing reasons, like genuine incompetence. Reasons of the sort that the child herself would, once she learns why her biological parents chose not to raise her and is capable of making a mature judgment on the subject, the child herself would, in those circumstances, be able to understand that the choice of the parents not to raise her involved no failure on their part to love her adequately. In a case like that, but only in a case like that, it is possible to fulfill one's strictly non-transferable obligation to love one's biological children without raising those children oneself. And it's worth noting in this regard that empirical evidence about adopted children supports the claim that the love of one's biological parents is important and irreplaceable to children. Researchers have noted that one of the greatest psychological difficulties faced by adopted children is the sense that they have been rejected or abandoned by their biological parents. On the other hand, one of the advantages to children of open rather than closed adoptions is precisely that open adoption often allows children to learn that their biological parents did and do love them and gave them up for adoption precisely because of that love. Further comparison between gamete donation and adoption might help to add plausibility to my claim that children have a prima facie right to be raised by their biological parents based on their absolute right to be loved by their biological parents. If biological parents were to place their children up for adoption for trivial reasons, because, say, having a child would interfere with vacation plans, we would consider that decision to be morally wrong, a failure to fulfill a serious moral obligation without a sufficiently weighty reason to excuse them. Further, we would think it wrong for a couple to intentionally take steps to conceive a child or to take actions with a high probability of resulting in conception when they know ex ante that they will not be willing to raise that child, even if the reasons are non-trivial and even if they really are incompetent. Consider the following case. Amanda and Arnold are in desperate need of money. Amanda learns of a local fertility clinic offering generous compensation for participation in a study on the effectiveness of certain new fertility treatments. They decide to participate in the study, foreseeing that Amanda will most likely become pregnant as a result. If conception does occur, they plan to give up the child for adoption as soon as he or she is born because their financial situation would make it impossible for them to care for the child adequately. Now, this case seems to be a moral equivalent of what gamete donors do. Just like Amanda and Arnold, donors perform actions that will foreseeably lead to their becoming biological parents while having no intention of raising their offspring themselves. If we think that Amanda and Arnold's actions are wrong in the above case, we should also think that the actions of a gamete donor are wrong, and for precisely the same reason, namely that a child has a prima facie right to be raised by his biological parents based on the absolute right to be loved by his biological parents. By way of conclusion, allow me to synthesize the argument and then point out briefly a few further implications for an ethical assessment of artificial reproductive technologies. My first claim was a metaphysical one. Human beings are essentially animal organisms. My second claim was about the source and nature of our obligations to others, that our general obligation to promote the well-being of others is specified largely by the nature and closeness of our relationships with others, as well as the importance of the other's need. I also argued that there is a non-transferable special obligation to provide what I have called personal benefits, benefits that only a specific person can provide, of which one example is the love of that specific person. Putting together my metaphysical claim with my claim about the source and nature of obligations, I stated that the biological parent-child relationship is itself a personal relationship in which the child is personally dependent on his biological parents, and that the most strictly personal benefit that biological parents can give to their children is the benefit of their parental love. Thus, biological parents have a strictly non-transferable obligation to love their children themselves, an obligation which is quite weighty given the unique closeness of the parent-child biological relationship and the importance of this benefit for the well-being of the child. Further, in order to love their children adequately, biological parents must raise those children themselves, except in cases of genuine incompetence. These obligations on the part of parents correlate to children's absolute right to be loved by their biological parents and to children's strong prima facie right to be raised by their biological parents. This line of reasoning provides a principled account of our intuitions about the wrongness of conceiving and or giving up children for adoption for trivial or mercenary reasons. And as we have seen, it applies perfectly to the case of gamete donation. Gamete donors, by acting in a way that will foreseeably lead to their becoming a biological parent, precisely on condition that they will not be called upon to raise the resulting children, thus act wrongly by failing to show adequate respect for the rights of their future children. Their wrong consists in a conditional willingness. It's conditional because there's no certainty that a child will actually result from their donation. A conditional willingness to harm their future children by depriving them of an important benefit to which they have an absolute right, the benefit of being loved by their biological parents. Now, what about the individual or the couple who uses donor gametes to conceive? Obviously, their situation is different, as they do intend, of course, to raise the resulting child. However, if it's wrong to donate gametes, then it would also be wrong to contribute to that practice by creating a demand for it, and further, choosing to conceive a child with the intention of alienating that child from one of her biological parents and half of her biological ancestry is in itself a failure to respect that child's rights for the same reasons. In addition, assuming a conjugal view of marriage as a comprehensive union of persons, which we'll hear more about this evening, conception with donor gametes, even when this is done with the consent of the infertile spouse, is also an injustice to one's spouse and a serious affront to marital unity. After all, conceiving with donor egg or sperm means having a child with a man or woman other than one's spouse. It's basically a sex-free version of adultery. Monogamy means not just refraining from having sex with any person other than one's spouse, but also refraining from having children with any person other than one's spouse. The result of this non-monogamous childbearing is also to introduce a fundamental inequality in the marital relationship due to the fact that one parent is biologically connected to the child and the other is not. Social science, experience, and the unanimous voice of world literature from Cinderella to Dickens show that this step-parent situation is a serious source of tension between spouses and within the family more broadly. To choose it ex ante, rather than accepting it as a side effect of the death of a parent, say, is a serious rupture within the family and usually to the profound detriment of the children as well. What should be a furthering of the marital union, the procreation of a child that is a manifestation and result of the spouse's two-in-one flesh unity, becomes instead a profound source of disunion and inequality within the marriage. In this paper, I have not dealt with the case of what is called homologous artificial reproduction, the case in which a married couple has recourse to IVF to conceive using the spouse's own gametes. This, too, I believe, constitutes an injustice to the future child by treating the child as an object of manufacture and thus not as a person equal in dignity to the parents. And it also seems to me to involve a subtle threat to the marital union by inviting technicians, in a sense, into the marital bed, giving them a critical role in bringing to fulfillment the act by which man and wife actualize and express their two-in-one flesh union. A full argument for these claims, however, will have to wait for another paper. Thank you.
Okay, I think we have time for a few questions or comments, so please feel free to go to the microphones.
Yes, I have a question for Dr. Moschella and any other panelist. But it struck me listening to the three presentations that the first presenter, Professor Brinig, spoke mostly in terms of I think relationship and gift, and especially Dr. Moschella's paper focused on benefit and right. And when I think of just personally what I would like from my parents, it's not so much a benefit because I have a right to it, a benefit of love, but a gift of love that goes with that gift of existence that I'm not sure is translatable, although it may have to be for legal purposes, into rights and benefits that way. So I wondered if Dr. Moschella or any of the other panelists had any comments.
Yes, I agree with you that it's funny to speak in this language about a relationship that seems so natural and that you would want to be, in a sense, a spontaneous sort of gift that involves also affection and everything else. However, I don't think there's an incompatibility between the two languages, and in a sense, which is why I go back and forth between the language of love and the language of obligation. Because really what I'm trying to explain is that it's just the concept of ordo amoris, right? That an order of loves, and that order has to be rationally determined, right? I gestured in my paper to the idea that we have some sense of obligation to love every single other human being, but of course that obligation needs to be specified, it needs to be ordered. And I think that we order it in large part by the nature of the relationships, the closeness of the relationships that we have with others. So it was kind of a rational reflection in some ways on applying this idea of the order of love, the specification of general obligations, to the parent-child case, analyzing that case to show that it is among the strongest and closest of relationships, and also one of the ones in which the need, at least on one end, is greatest, to show that that love ought to take among the first priority of the parents, right, and then sort of see how that flows from it. So yeah, I agree with your concern, but really I see myself as simply translating the language of love into a language of right and benefit and so on that enables it to be in conversation with the philosophical and legal discourse on these matters.
My name is Josephine Quintavalli, and I've come over from London specifically to this conference because I wanted to raise the issue of what the United Kingdom is contemplating doing in the forthcoming months, probably before our Parliament in the new year, which is the creation of 3-parent embryos. So I agree wholeheartedly with everything that anybody from the panel has said, but mischievously I want to ask this question of Professor Moschella. Is there not perhaps a risk of over-privileging genetic origins? As I said, we are contemplating creating embryos in the UK using 3 or even 4 parental genetic sources. And should all those who have contributed such genetic material be involved in raising eventual children?
Well, actually, I would say that my argument, I'd need to obviously develop it further in specific connection to this case. My argument would simply explain why that should never be done, right? Because there's obviously the connection here. It's not just about any sort of genetic connection whatsoever, but there's the larger sense of the connection to the good of marriage as a whole, right? And that marriage being the setting which is most favorable to, which is the only setting worthy of the dignity of a new human being, to bring a new human being into the world, the only setting in which that new human being can come into the world on a footing of fundamental equality with the parents, because through the marital act, parents do not produce a child, right? They do something which they would otherwise have good reason to do, namely actualize and express their marital union, and they are willing, in correct cases, right, they're willing to accept as a gift that supervenes on that action the resulting child. So the child isn't produced, it's hoped for and ready to be welcomed as a gift in whatever condition or type it may, he or she, I should say, may come. And that reflects that fundamental unity. And it also then reflects that idea of being conceived as a gift, as a product, well, not a product, but out of an act of love, which is very much in line with the dignity of the human person. Now, so to add these manipulations where you take out the ooplasm, right, and because of problems with the mitochondria in the ovum of the woman, and so you add a third source of genetic material there. That clearly is an issue in terms of just the manufacture of a child and its lack of a kind of logic of domination over the child. It's also an issue, excuse me, in terms of identity confusion, right? And it's going to be an issue in terms of there is no natural relationship among the parents that corresponds to this three-party conceiving relationship, and therefore there's no sort of ideal setting then in which those three biological parents can act as one unified parental principle in raising the child, which is what the child needs. So it kind of goes back to why marriage is inseparable, I think, from this overall conversation.
We call it genealogical bewilderment in the United
Yes,
Kingdom.
yes, I've heard the term. It's a very good one.
Yes.
Hi, good morning. I come from Universidad Panamericana in Mexico City. So this is to Professor Melissa, and I agree with you, but I think your arguments against gamete donation work also with adoption. In adoption, the children are not raised by their biological parents, and there is a possibility they live all the consequences and problems you mentioned. I'm thinking the problem of identity that you mentioned too. Yeah. So, can you mention more differences between the consequences of adoption and of gamete donation? Or, why do you agree with adoption beyond that the child already exists? I agree with that too. No matter children are not raised by their biological parents.
Yeah, so time permitting, I would have said a little bit more about this to clarify it in the paper, so I'm glad you bring it up. So I do think the key feature is that the child already exists, right? Because once a child exists, well, you have to do the best that you can in those circumstances to give care to that child, right? So if, because of tragedy, because of malice, because of whatever, right, the biological parents will not or cannot raise that child, then you have a human being in need, and somebody has to generously step in and do the best that they can to raise that child. And the studies have shown that, I mean, right, we recognize that that's a non-ideal circumstance to begin with. It doesn't mean that adopted children can't, fare just as well or even better, right, than some non-adopted children. But in the sense of the ideal, nobody would claim that to be the ideal, right? And I think also it makes a big difference because if you recall, the one thing that strictly biological parents are irreplaceable, the one thing that they and only they can do is provide their specific personal love to those children. So it makes a big difference, in other words, to children to know themselves to be loved appropriately by their biological parents. And so I think, more research would need to be done to see if this is true empirically, but it seems to me, and anecdotally it seems to be true as well, that adopted children who know that their biological parents didn't just abandon them casually and recklessly, or just didn't care about them at all, but the adopted children who know their biological parents were in dire straits, it was a mistake, it was whatever, and they had a heart-wrenching decision of whether or not to keep the child, and they decided, in a sense, because they loved the child and wanted the best for that child, that the best thing would be to give it to another loving couple much more competent to raise them. So in that situation, as a child, I think, and as the child grows and is able to understand the reasons behind this, they can really come to peace with that knowledge and say, okay, it's not that my parents rejected me, not that they didn't care about me, but that there was a tragedy involved. In the same way that a child can come to terms with that when their parents died, right? It's not that my parents didn't care about me, but they had no control over this, right? For all that I know, it seems that they loved me, but then they died and couldn't raise me, right? It's the same sort of thing. Whereas the trauma psychologically, I think, comes from any indication that not being raised by one's biological parents is due to a lack of appropriate love on the part of those parents. And that lack of appropriate love and respect is always present in the gamete donation case because it's intended ex ante, right? What you're doing is choosing to do something that you know will foreseeably result in having biological children, and you do that really with no particular expression of concern for their well-being, certainly without any intention to fulfill that obligation to love them with a special and prioritary love, right? I mean, you may have some general well wish for them, but that's not enough, right, in terms of what your biological children have a right to from you. And this is borne out. I didn't want to go into the empirical studies because you can always, talk about flaws in the studies, but this is definitely borne out if you just take a look at websites in which donor-conceived children talk about their stories, or at the studies, My Daddy's Name is Donor, that comes out. I mean, you see the concern and the uneasiness on the part of donor-conceived children about the fact that, the donors very often did it just for money, or they don't care about them at all, they don't even care if they exist, right? That is a kind of deep wound that my biological parent, who really is something to me, could care less whether or not I actually exist.
So your strong argument is the one of the love, not of the biological relationship. So that's
it's just that the
perfect.
relationship
Okay.
is what grounds the fact that you have a particular special obligation to love that person. Yeah.
Thank you.
For the sake of time, I think we're going to end the session, but I want to thank the speakers so much, and I'm sure they'll be happy to take some questions afterwards. So Thank you so much.